And so what the trial court said was Ms. Hancock was required to turn over the child to DCS. The problem is there is nowhere in the order that says what she was supposed to do. So assuming it's true that she received notice in some form or another when she's at that motel, what was Ms. Hancock expected to do? The trial court claims she was and the state now seems to claim that she was expected to take the child back to DCS custody, wherever that may have been, but the order doesn't tell her to do that. And what it seems to be saying is, or what the state seems to be saying, is that Ms. Hancock's obligation to that child ended the moment she got some form of notice from her attorney, meaning conceivably she should have just left her at the motel, left the child at the motel, that is, because there was nothing directing her to do anything else. And if the state's theory is correct, then her obligations and relationship with the child ended the second she received notice of that order. So much so that she was just a normal citizen with no parental relationship with the child at all. And there's nothing really that supports that theory, but it is what the trial court strongly suggested when it said that she had some obligation beyond, or some obligation to take some affirmative step upon receiving notice of this order.
You're starting to get into your rebuttal time.
Okay.
But take your time.
But I'll just conclude with that. If DCS wanted to take custody of this child, there was a way to do it. They didn't do it that way. If DCS wanted Ms. Hancock to do something, they could get a court order directing her to do something. They didn't do those things. And because they didn't do those things, there is no reason to expand dramatically this custodial interference statute to capture this behavior. There's a way to do all of this. There's a way DCS should know how to do this. But they didn't do it, and because of that, this conviction should be reversed.
Thank you, sir. You still have your full 3 minutes.
Thanks.
General?
May it please the court, Catherine Decker representing the state of Tennessee. This court should affirm the defendant's conviction for custodial interference under subsection 306A2. This is one of those rare cases where there's no question about what the defendant did and what her intentions were. So we haven't discussed the facts, but I think it's important to briefly summarize what the defendant admitted when she was arrested and spoke with law enforcement. That she admitted that she ran with her daughter, her 12-year-old daughter, with the intent of preventing law enforcement, the enforcement of the order that put that child into DCS custody. So very briefly, the facts. So the defendant acknowledged that she became aware that DCS was investigating her. She knew that. They came to her home. She then took her child to a hotel and checked into that hotel. While at the hotel, the juvenile court, in fact, did sign the protective order that placed her child into DCS custody. Her attorney obtained a copy of that order. Her attorney brought that order to the hotel. You can kind of see this in a video of the lobby, but also defendant has admitted this, that she reviewed that order with her attorney.
Did the order, as suggested by defense counsel, tell her what to do with the child?
It didn't tell her what to do with the child, but it's not about an order telling her to do something affirmatively. In this case, it was clear what she couldn't do. You can violate an order by affirmatively doing something, or not doing what the order affirmatively tells you to do. But you can also violate an order by taking actions that thwart the enforcement of that order.
So the state's position is by her and I'm going to use the word concealing her child from DCS, is the, I guess, the point that you're saying that she violated the order?
Correct. Correct. By the common just the common dictionary definition of violate. So just to continue with the facts, so she removed her child, so at the hotel.
Counsel, let's play around with that just a little bit off Judge Campbell's question. I mean, for her to violate the order, she has to have some duty under the order, right? She has to have some duty under the order for her to violate it. Just like me, I would have to have some duty under that order before I could be held to violate it.
Well, Ian.
So what's her duty?
So that order gave DCS the custody of her child, and she became at that point the non-custodial parent. And so at that point, her duty was to, if you just look at the common law, just the common dictionary definitions.
She's not charged under A1 though, she's charged under A2. A1 deals with custody orders.
But A2 deals with the non-custodial parent.
With visitation, after visitation had expired.
And that's, I'd like to address that in a second, but that's correct. But it's really A2 that is the proper subsection to go under, because when the protective order came down, DCS became not the custodial parent, but had custody, and she became the non-custodial parent. So that's why the state properly went under subsection A2.
Do you agree, though, that A1 addresses violations of custody orders?
A1 just doesn't apply because, just a moment.
As I look at the statute, it looks like it has a natural structure to me. That A1 is a structure that allows for criminalization of violating a custody order. A2 is a statute that criminalizes violation of a visitation period, after an expiration of a visitation period. The statute looks pretty clear to me that it's custody on the one, visitation on the other. Do you disagree with that structure?
I don't necessarily disagree with that structure, but the reason why A2 is applicable, well, let me just talk then, and I'll just abandon my outline. Let me just talk right now about the period of visitation, and why it was appropriate to go under A2. And A2 is appropriate because at this point the defendant is the non-custodial parent. So about the language, the phrase that includes period of visitation, and as I've argued in my brief, I think the trial court was proper in not including that phrase as an essential element when the defendant detains because of the application of the last antecedent rule. And so in that...
Would you agree, though, this argument was not made in the trial court by the state?
Correct, and this is just a de novo review, so I think that this is the proper construction of the statute, because the last antecedent rule is just a common maxim, and when you apply it, it's clear that phrase, the expiration of the parent's period of visitation, is a phrase that would only apply to removing the child from the state.
Well, is that clear? Because the rule of the last antecedent gives way to ordinary English, right?
Correct. If there's concerns that overcome the rule.
So how about this? So I don't know if you've had the opportunity to read his book, but Neil Gorsuch wrote a book called A Republic If You Can Keep It. And in that book, he discusses the rule of the last antecedent. And the example that he gives is, let's say that you have a friend who comes to you and says that she would like to meet an actor or a director from the last Star Wars movie. You would not believe that she would be satisfied by meeting an actor from the latest Zoolander. And that's exactly what we have here, right? So why doesn't the antecedent apply, why doesn't the limiting phrase apply to both of the antecedents here? Particularly when you look at A1 and how A1 is structured.
It doesn't apply because the procedure is that you look at the structure, the syntax, and then you apply it. But if there's concerns that overcome the application of the last antecedent rule, or give you some notion that there was a different intent by the legislature, then you don't apply.
Okay, so you didn't discuss the impact of A1. You talked about A5 in your brief, but you didn't discuss the impact of A1. So A1 also has that antecedent, except that it applies to custody orders. And in A1, it's just removal of the child from the state. But in A2, we were dealing with visitation orders and removal of the child from the state, but now we're also dealing with detaining the child. So it looks to me like the legislature's creating a structure whereby with custody orders, we're worried about one aspect. With visitation expiration, we're worried about different things. And so isn't that affirmative evidence that the legislature may not see itself as being bound by the rule of the last antecedent?
I think if I then discuss the period of limitation, that might clear things up. And also, A2, so I think still A2 is the proper way to go here. And so let me discuss that phrase, the period of limitations, expiration of the non-custodial parent's period of limitation. And so the defendant is the non-custodial parent. And so the question is, what does this period of limitation refer to?
The period of visitation?
I'm sorry.
No, you're fine.
The period of visitation.
Sure.
And so, of course, it could refer to, just if you interpret the word visitation literally, there are situations where, the child is somewhere and the parent is not trusted, so they actually visit the child, supervised visitation or whatnot. Well, clearly, that's not how this phrase is interpreted, because even the defendant speaks of it in terms of, the every other weekend or 1 week, during the summer, that kind of visitation, if you will, but really then implied is a broader interpretation. And it's not just visiting the child where the child is physically located, but rather it's the period in which you have the right to exercise custody and care of that child. You have the right to take that child from the other parent for the weekend or for that week. So it is broadly, and even the defendant interprets it more broadly than just the literal period of visitation. It's the period where you have that right to remove the child into your care and custody, and if you will, visit with the child in your own home. And so what is that period of visitation? Yes, it can be every other weekend, a week, but why not 6 months? Every other week? Why not 365 days? What limits the period of visitation to just the standard every week, every other weekend, or the 1 week? So it really is a broad, it has to be, because it can't just be the literal visiting your child.
Isn't it really more simple than that? I mean, when you look at A1, the reason that the phrase A1 doesn't include detain your child, because in A1 we're talking about someone who has custody. And so you can't detain your child when you have custody. In A2, though, we're talking about situations where the non-custodial parent has visitation. And so it makes more sense there for the legislature to put in language that says when you detain a child beyond the expiration of the visitation period, that's when the crime is committed. Otherwise, what I think you would be saying, not you, excuse me, Gerald, I didn't mean to imply that. What the state's argument may be is that a crime is just committed when the non-custodial parent detains the child, period, in violation of an order.
And that's the way this indictment was drawn up, wasn't it? The indictment itself doesn't talk about visitation or custody, correct?
Correct, but can I just say one thing first about A1? Yes. A1, we couldn't actually go under A1 because it's removed the child from the state.
I know, that's the point, is that
yes.
A1, when it deals with custody, doesn't have detain the child, because you can't detain the child in a custody situation. You can in a visitation section, and that's why the legislature is including detaining the child when we're talking about visitation expiration.
But I think even the defense has acknowledged that this subsection A2 would apply if the parent, if you just look at the standard custody arrangement of every other weekend or say a week. And so, for example, the parent has spring break, and so picks up the child at spring break. And while he has that child, the protective order comes down. Then that parent keeps the child beyond spring break, so that under the defendant's interpretation, that element of the period of visitation has now expired, has been met, and that parent who has now detained the child within the state while there's this protective order has actually violated subsection A2.
Right, and that's, I think, isn't that what the defendant is arguing, that the expiration of the visitation period actually modifies detaining the child, right?
Correct, but what I'm saying is even the defendant acknowledges that when, in that scenario where the parent has detained the child, that they would be guilty of custodial interference under A2.
Okay.
So I don't think the defendant is saying in that situation where that parent merely detained the child beyond that spring break week, and there was an order, a protective order placing that child in DCS, I think even the defendant would acknowledge that parent has violated A2. I don't think the defendant would say, no, that's not a violation because they should have been indicted under A1.
If the expiration of the visitation period is an essential element of the offense, is the remedy dismissal?
No, because actually in the because the indictment does more than, because the indictment does what it should have done, and that is...
The indictment doesn't talk about custody or visitation at all, correct?
Correct, but the indictment does what the indictment gives enough notice of the elements of A2 that would inform the defendant that she has been indicted under Section A2, and that is because...
Well, it actually says in violation of A2 in the indictment, does it not?
It doesn't mention A2,
Okay.
But it mentions 3913-306, so there we are in the statute in general. But then it also says, did detain the child. So we know we're not in A1, we know from what she did was detain the child within the state with the intent to violate a temporary permanent judgment or court order. That language, detain, and the language I just read, only appears in A2. So it's given... Language in
A2 includes language including custody and visitation, correct?
Correct, but under the, pleading requirements, this language was enough to inform the defendant that she was being indicted under A2.
Assuming that the expiration of the visitation period is not an essential element, right? If we assume that it is, I'm not saying that this court is finding that, but if we were to assume that's the case, wouldn't that have to be in the indictment for it to be valid? This is not a mens rea issue, for example.
Well, but there's enough information in here to direct the defendant to subsection A2, and so she would know that's the subsection she's been indicted under. It's not a situation where the defendant is left without knowing, because essential elements are missing, the defendant is left without knowing what subsections, what statute she's been indicted under. She knows she's been indicted under A2 by what's in the indictment. So no, so even if you disagree with my interpretation, no, it doesn't require dismissal of this case. But so...
Have about 3.5 minutes. 3.5.
I think that I'm going to rely on my brief and also the discussion here about the period of visitation to say that there is no concern that the defendant has raised in her brief or here that would require overcoming the application of the last antecedent rule. That is a common maximum of statutory construction. It applies here, and nothing tells this court to overcome that.
Except A1.
I think still A1 doesn't, because if the parent detains the child, and especially the non-custodial parent, which the defendant is, if the non-custodial parent detains the child, it is A2 that applies.
Okay. Counsel, thank you. I appreciate that.
Let me just turn briefly then to issue number 3, and that is the trial court informing the jury that this order was enforceable as a matter of law. And of course, I think as Judge Greenholz hit upon in questioning of defense counsel, there's no question whatsoever that this defendant knew about the order, knew the contents of the order, knew that this order placed her child into DCS custody. She knew every aspect of what this order was about. She had notice of everything that was significant about this order. That's in fact why she ran with the child, because she knew exactly what the order said. But in any case, the reason why, even if it was harmful, and there's no law that said this would be harmful, but even if this were error, I meant to say, even if this were error, and there's no law saying this kind of instruction is error, it's completely harmless for 2 reasons. One, this instruction comes in the same paragraph where the court is saying there's no mistake of fact or law. That's not a defense. So it really doesn't matter whether the jury is instructed that there's no defense that this order might not be enforceable. There's nothing, the jury can't do anything with that one way or another because it's not a defense. But second, even it's not possible at all that the jury would not have made the exact same finding that this was enforceable, even if this were a matter for the jury. And finally, it's not true that because of this instruction, the defendant could not argue to the jury that she didn't violate this order because it wasn't clear enough, et cetera. Of course, they could always make that argument. This does not prevent them from doing that. That's a jury argument. They could absolutely have made that. About sufficiency, and as I've stated in my brief, there's no definition of violate in the statute, and so the jury is free to use the common meanings of violate, and one of those, those are disregard, fail to show proper respect for, and interrupt. And even though this order did not, this order did not compel her to do anything by thwarting its enforcement. Admittedly, this is why she ran. She wanted to thwart the enforcement of this order. That thwarting of the enforcement of the order comes within the common definition of violate: to disregard, to fail to show proper respect for. The trial court was completely correct in saying that this is exactly a thwarting, a violation of this order.
And one of the things that really concerned me about these briefs when I first read them was the issue, and maybe it's not an issue, I'm just missing something, that this was not prosecuted in DeKalb. Was it DeKalb County where the juvenile order was from? I mean, if she's violating an order, it's an order out of not Williamson County, it's an order out of DeKalb, correct?
But Williamson County had jurisdiction because when she fled, she left the hotel and drove down to a home in Williamson County, and that's why they had jurisdiction.
So is a continuing offense kind of argument, is that what you're making?
Yes, she hid her child in a home in Williamson County, and that's why it was prosecuted there.
Okay. Any additional questions?
Judge, thank you. No.
Any additional questions? Thank you, General Decker.
Thank you, Judge.
Just ask this court to affirm the conviction.
Remember, you still have your 3 minutes if you like.
I guess I'll just pick up where we left off and say you're absolutely correct that this could have and probably should have been done in DeKalb County, where there would have been more options available and the judge would have been more familiar with the situation, proof would have been more available. We agree that
That issue was never raised in trial court.
it actually was raised. There was a motion about venue and jurisdiction, but it got dropped eventually because we agree that jurisdiction was proper in Williamson County. The
Okay.
point about the availability of DeKalb County is just to say there is an easier and more typical way of doing this, and it would have been through something like contempt in DeKalb County, and that does not require the contortions of the statute that the state's now asking for. So the fact that there's another available remedy is why we bring it up, just to say there was an easy way to do this, and it doesn't require all of the stuff that the state is now asking the court to do.
So, counsel, could you address for me, if I'm not interrupting, could you address for me the argument that your friend makes on the other side with respect to the enforceability of the order on the sufficiency of the evidence question? Why, even if the order does not direct your client to take affirmative action, why is it not violating a court order when she takes actions to thwart its enforcement?
Well, I would start by saying I don't think the proof established that she was attempting to thwart
Let's
its enforceability.
assume that that's the actual fact that she was. Let's just assume that for sake of argument. If she was trying to thwart the order, would that be within the ordinary definition of violate so as to impose criminal liability?
I don't think so, particularly in a context where the order is silent as to anything she is expected to do. So when the state says thwart, that would mean that she is doing something that's preventing the attachment, but she didn't do anything like that, particularly when her attorney is actively trying to reach DCS and the investigator, and they're just refusing to contact the attorney for whatever reason. And
Well, let me back up though for a second. You still have a situation where it can be inferred that you have a concealment. You know, the DCS is trying to get this child, and you have active means being done to keep that child hidden.
I'm not sure there's evidence in the record to show what DCS was trying to do to obtain the child in terms of were they contacting Ms. Hancock to actually do that. What we know is that she left the county after she was at least somewhat informed of the contents of this order. But what we don't know is, or what we can't know, because the order doesn't say, is what she was supposed to do. So now the state's saying, well, she wasn't supposed to conceal or thwart, but they haven't identified precisely what that is or what thwarting meant in this context. Because all she did was contact her attorney and drive to her attorney's home. That's all she did. When DCS or the investigators tried to find her at her attorney's home, they did so without issue. They went to the house, she was there, they took the custody of the child without incident. There was nothing more than that. That by itself is not enough to constitute thwarting, and I don't think would be enough to constitute violating the order, even under the state's kind of very broad definition of violate, because again, without some specific directive from the court via its order, there's nothing, or what Ms. Hancock's obligations were unclear.
Mr. Ridley, your time has expired.
Okay, I'll stop there then. So we just asked the court, unless it has further questions, to reverse for the reasons in the brief and what we've discussed. Thanks.
Thank you.